Something big just shifted inside the U.S. immigration system, and almost nobody noticed. On November 3rd, 2025, while most people went about their day, USCIS quietly sent a brand new proposal to a White House office known as WARA, the Office of Information and Regulatory Affairs. This might sound routine, but it could reshape one of the most confusing and feared rules in all of immigration, the public charge rule. The proposal hasn't been made public yet. It's not in the Federal Register, which means we can't read the details, but the move itself signals something major, Fran. If you're waiting for a green card, preparing for a visa interview, or planning to adjust your status, this could directly affect your future. Right now, families are wondering whether this rule might once again decide who gets approved and who gets denied. So what exactly is the public charge rule? Why does it cause so much fear? And why do small changes to it matter so much? In the next part, we'll break it down in simple words and show how this single policy became one of the most powerful tools used by immigration officers across the country. The public charge rule sounds complicated, but here's the simple truth. It's a test used by immigration officers to decide whether a person applying for a green card might depend mainly on government support in the future. The idea isn't new. It's rooted in an old law called the Immigration and Nationality Act. The goal has always been the same: to make sure people coming to the United States can support themselves or have a sponsor who can help. If an officer believes that someone is likely to become a public charge, that single decision can lead to a denial of the entire green card application. That's why this rule causes so much fear. But here's what many don't realize. Using one government benefit doesn't automatically mean you'll fail the test. Over the years, the definition of which benefits count against an applicant has changed several times. Those shifts have created confusion and panic for thousands of families. Many immigrants have asked the same question: which programs are safe to use, and which ones can hurt their case? To understand that clearly, we need to look at the current rule in effect today. In the next part, we'll go over exactly what USCIS considers safe right now under the 2022 version of this rule. Right now, the rule that USCIS follows is the one published in September 2022. That update was meant to clear up confusion and remove the fear caused by earlier proposals. Under the current rule, immigration officers only consider two specific types of government assistance when deciding if someone could be a public charge. The first is cash assistance for income. Programs like SSI, which is Supplemental Security Income, and TANF, which stands for Temporary Assistance for Needy Families. These programs give people direct cash each month to cover basic living costs. The second is long-term institutional care paid for by the government, such as a nursing home or mental health facility where the government covers the bill for your stay. That's it. These are the only benefits that count under the 2022 rule. Everything else, the non-cash benefits, are considered safe right now. That includes SNAP, also known as food stamps, the WIC program for women, infants, and children, regular Medicaid coverage, and housing vouchers or Section 8 assistance. Using these programs for you or your family does not make you a public charge under today's rule. But if this is the current policy, what exactly is USDS planning to change with the new proposal? That's the big question we'll explore next. So what might USCIS be planning with this new proposal? Is this a small adjustment or a major return to the stricter rules that created fear a few years ago? Right now, no one outside the government knows the full details. The proposal submitted on November 3rd is still under review at the White House office called WARA until that review ends and the proposal is officially published in the Federal Register. Everything remains confidential. That uncertainty is what worries so many families. Some believe the government might be considering adding back certain non-cash benefits to the public charge test, like SNAP, WIC, or Medicaid. If that happens, it could make applying for a green card even more difficult. However, it's also possible that the update is simply technical, maybe just a clarification or administrative adjustment. We won't know until the official text is released. For now, it's critical not to panic. Nothing has changed yet. Every case is still being judged under the 2022 rule. But this is the first official signal that a new rule may be coming. And when that happens, the way officers review your case and even the outcome could shift dramatically. In the next part, we'll look at how a future change like this could impact green card applicants both inside and outside the United States. If the new rule adds more programs like SNAP or Medicaid back into the public charge test, it could create serious challenges for thousands of applicants. For people applying inside the United States, anyone filing Form I-485 for adjustment of status could face more scrutiny. Officers might review an applicant's use of benefits in greater detail, which could lead to longer interviews, additional document requests, and more delays in case processing. For applicants outside the country, the Department of State usually follows the same direction as USCIS. That means consular officers at U.S. embassies could start examining a sponsor's financial documents and support affidavits more strictly. Even a small history of benefits used by a family member might become a reason to deny a visa. The biggest impact would fall on families already living in the U.S. Many parents would face an impossible decision, whether to keep their U.S.-born children enrolled in food or health programs or withdraw them out of fear it could harm their green card applications later. This uncertainty is what makes immigration so stressful. Every change, even before it becomes official, creates confusion and fear in the community. In the next part, we'll go over who exactly needs to pay the closest attention to these updates and which groups are most likely to be affected first. So, who needs to pay the closest attention to these upcoming immigration changes? First, anyone currently filing for adjustment of status inside the United States. If you're preparing Form I-485, any change in the public charge rule could directly affect the evidence you need to submit or how your case is reviewed. Second, people waiting for interviews at the National Visa Center or a U.S. embassy abroad. Even if USCIS approves your petition, the Department of State conducts its own version of the public charge test during your visa interview. They use the rule that's in effect on the day of your interview, not the day you applied. Third, green card holders sponsoring their family members, spouses, parents, or children. And if new restrictions are added, it could make your sponsorship process more complicated and create new requirements for proving financial stability. Fourth, anyone planning to apply in the next year. If you're collecting documents or saving money for your application, staying informed right now is essential. And finally, some people are not affected at all. The public charge rule generally doesn't apply to humanitarian immigrants, including refugees, asylees, or victims of trafficking. These groups are exempt from the test under current law. In the next part, we'll look at the government's timeline and what happens step by step before any new rule can officially take effect. This news might sound urgent, but the truth is government rule changes take time, often many months. There's a strict process that every major regulation must go through before it becomes official. Here's how it works. Step 1 is the WARA review. Right now, the proposal sits with the White House's Office of Information and Regulatory Affairs. They review the rule privately to ensure it meets all administrative and economic standards. This review period can last up to 90 days, sometimes even longer. Until that process is complete, nothing moves forward. Step 2 happens when WARA finishes its review. USCIS then publishes the full text of the proposed rule in the Federal Register, which is the government's official journal for new laws and regulations. That publication is the key moment. It's when the public finally gets to see exactly what the agency is planning. Next comes Step 3, the public comment period. Once the rule appears in the Federal Register, the government opens a 30 to 60-day window for the public to respond. Anyone can submit comments. Individuals, lawyers, advocacy groups, and UCs is legally required to review and consider each one. These early steps show that nothing happens overnight. We're still in the very first stage of a long process. In the next part, we'll cover what happens after the public comment phase and how the final rule eventually becomes law. Now that you know the process takes time, let's focus on what you can do right now. This is your simple 3-step action plan to stay ready and avoid unnecessary stress. Step 1. Don't panic. Nothing has changed yet. The current 2022 rule is still in effect. Your application will continue to be judged under that version of the law, until an official update is published and approved. Making quick decisions out of fear, like unenrolling yourself or your children from important health or food programs, could do more harm than good. SNAP, WIC, and regular Medicaid are still safe to use under the current rule. Step 2. Stay informed. The biggest risk is missing the moment when the new proposal is actually published. When that happens, you'll want to know immediately. Stay connected to reliable immigration news sources that explain legal updates in clear, simple language. Knowing the facts early will give you time to plan calmly and correctly. Step 3. Get organized. Even though you don't need to change anything yet, review your own situation. Know which benefits your household receives and understand what programs they belong to. Having this information ready will make it easier to consult a lawyer or prepare documents if new rules are introduced. In the next part, we'll wrap up with final thoughts on why staying calm and informed is the smartest move you can make right now. In moments like this, information is your strongest protection. Immigration rules can shift quietly, but they always leave signs before they change. By paying attention to these early signals, you give yourself the advantage of time to prepare, organize, and make smart choices for your family. Remember, as of today, the 2022 Public Charge Rule is still the law. Your application, interview, or pending case will be judged by that standard, not by rumors or speculation about what's coming. The new proposal is only at the first stage of review, and months will pass before anything becomes official. Don't let fear guide your decisions. Instead, let awareness and preparation lead you. The more clearly you understand the process, the less control fear will have over you. If this update helps you feel more confident about your case, share it with someone who needs to hear it. Many immigrant families are living with uncertainty, and clear, accurate information can make all the difference. Thank you for staying informed and proactive. In the next part, we'll begin exploring what future updates to the family-based visa policies might look like, and what kinds of changes the government could introduce next. Thank you for watching and for trusting this channel to keep you informed. Remember, nothing has changed yet, but being prepared puts you ahead of the curve. Stay calm, stay organized, and keep following reliable updates as they happen. If you found this helpful, share it with your family and friends who are also waiting for immigration news. Accurate information can prevent fear and help people make better decisions about their future. Make sure you're subscribed and have notifications turned on so you never miss an important update. We'll continue to read every new proposal, analyze every detail, and explain what it means for you in clear, simple language. This journey is not about panic, it's about preparation. We'll be here every step of the way, helping you understand each change as it comes. Thanks again for watching, and we'll see you in the next immigration update.